see a lot of familiar faces because we have some repeat attenders, which is awesome. Some of you we've seen for 7 years. We're wrapping up our 7th year of doing this event. So welcome. We want to make sure she signs in and gets a prize form. So today we're doing legal bingo. Every month, the topic changes, and I'm just going to buzz through some housekeeping things. If you're here in person, the restroom is down the hall. There's drinking fountains, and then BrightstarCare provided us with coffee and pastries, as I see some of you have taken advantage of, which is great. If you're online, so this is our online, and this camera here is on you guys, so we can have a fully hybrid meeting, so you can wave to the people online. We do have a few online. And so we're recording this. We're going to post it later on our website for later viewing if you miss it. And even though it's bingo, for those of you who are online, we do have the bingo forms that the people in person have. They're in the Google Drive. And if Sarah hasn't already, she's going to post a link to that drive. And she did already. She's going to post a link. There's a link to that drive in the chat box. You may have to repost it because as people come into Zoom, I don't think they can see the chat box. So we'll get that for you if you don't have it. But you can get the the bingo form, and then any other handouts that the people here in the room have, you can get those so you can feel like you are participating. So what else? If you're on your phone, *6 on your phone to ask a question, or if you're on Zoom, just unmute your mic and start talking. For those of you in the room, if you do ask a question, I'll either come to you or just repeat the question so that everybody can hear. And what else? Feel free to get refills if you need to. I think that's it. Did I miss anything? Oh, that's a good question. So this is legal bingo, but you guys all have 6 of the same cards. You can play one or all of them or a couple of them. I just wanted you to have all the words because Samantha's going to cover. When I was typing these out, there were a lot of words I didn't know. I was like, oh, this will be fun. So I wanted you to have the words so that you could take notes. So it's kind of bingo, but like non-competitive bingo, but we do have prizes, and how we're going to do the prizes is just like we do every single month. If you're here in person, you filled out a prize form. If you haven't already, make sure you do, because Samantha brought some amazing prizes. So we go back and forth a lot about like tchotchkes to give you guys, and a lot of you don't want them because you're downsizing. You don't want clutter, and we don't want you to have it either, because it's eventually we'll probably be decluttering it and throwing it away somewhere. So we always talk about we talk about what are the best things. Well, Samantha has brought some amazing homemade food items that she made, and I'll let you explain those if you want. At the end, we're going to draw for these, and we also have the basket that Stacy always brings from I'm drawing a blank, ClearCaptions. And so she brought that this morning too. So we have lots of great prizes for you if you're here in person. And if you're online, this is just incentive for you to come in person so you can also be up for prizes. But you can get the form again on the Google Drive. I think there was somebody who joined. If you join after, you can't see the chat from before, so you might want to post it one more time. And then to our fabulous sponsors, we have great sponsors that help make this event free. We have a hybrid meeting host that makes it look really pretty on the screen there and records it and streams it live on Facebook and YouTube for us. We rent this room. We do the Indie Star ad that probably a lot of you see every month. So there's a cost to this every year, and we could not do this without our sponsors. So we've got assisted living Locators here today, Trilogy, and then Majestic Care. Eagledale Florist does the beautiful flowers. Brenda's here from Eagledale. Where are you, Brenda? There you are. And ClearCaptions, like I said, and BrightStar Marquette Manor is also a sponsor. Marquette Senior Living, sorry, they dropped the Manor at some point. And speaking of Marquette, we are going to be doing, I think it's on one of the slides, we're going to be doing a senior community tour sometime in November. The date is to be announced, to be determined. We did one with Majestic Care in September. We're doing Trilogy. I think we're going to be doing a couple, like a progressive lunch type thing with Trilogy. And then Marquette is in November. So stay tuned for those. We'll put out the dates and times. You don't want to miss it. It's a great opportunity to tour as a group, so you don't feel like put on the spotlight at a community. You know, there's power in numbers, right? So you're in numbers, so you can listen to what other people ask, the questions that they ask, and then so look out for those based on Marquette and Trilogy coming there. So that we're gonna we have to meet here from Stinson Law, and the rules. So I'm just going to randomly call the name of one of the words on our cards, and you can use Samantha give us these little erasers to mark your bingo. I just you can use this for later to note a few questions and use these as your markers. And then as we call it out, Samantha will give you the definition of that. You can mark your card one or all of them. They're playing all of them. How many bingo fans do you have in the room? They're like some of the bingo people. You guys play like multiple cards, right? So yeah, maybe you're right at home here. It's not as competitive. This is more like for knowledge educational purposes. So those are all the rules, really. I mean, if you do get a bingo for the fun of it, you can shout out bingo. If you're at home and you get a bingo, you can shout it out too. Just know that there's probably a lot of people that have bingo too at the same time because they're all the same cards. So, all right, without further ado, we'll get started. I'm just going to grab one of these so I know the words to call out. Yeah, I know. I have one. I lost it. There we go. All right. Oh, yes. Let's do that. Let's, Samantha's going to start by introducing herself first.
All right. Good morning. My name is Samantha Lamberth. I am with Stinson Law Firm. We are an elder law and children's law firm here in Carmel. So our lead, Jeffrey Stinson, is a certified elder law attorney, which means he had to go to extra schooling and a lot of extra knowledge to specialize in this field. He's one of 15 with certification in the state of Indiana. So definitely knows what he's talking about. We help individuals with Medicaid, pension planning, special needs planning, estate planning, protection planning, wills and trusts, things like that. So that's kind of what we do. I am not an attorney, so please note I have to do my little extra thing here is for general knowledge and not as legal advice. But before I joined this law firm, I was a chef for over 20 years. So if you have questions about food, I'm happy to answer those.
That's fun.
All right, so let's go.
All right, let's go. Okay, so I'm just going to call out the random words. You can mark it on your page. Feel free to take notes. It's got lots of note pages there. And as you're doing that, Samantha's going to give you the definition of that word. Okay. All right. Let's start with caregiver agreement. Caregiver agreement.
Caregiver agreement. All right. So, with Medicaid and Medicaid waiver, the caring for someone can get funds to pay for, to funds. I'm already starting out bad. Thank you.
There.
That's better. Now I can think. So if you're a caregiver for a family member, you can receive money. It's a program through Indiana, but it has to be very strict regulations. And one of those regulations is by putting together a caregiver agreement. So it is a document that will help your loved ones be paid to care for you slow down.
Okay. And this is a camera and that's a camera. I'm saying that just for most of myself. It's a caregiver agreement. Any questions over caregiver agreement? Yes, ma'am. Does that include spouse? That's the question.
It depends on what Medicaid you're looking at. Some of them do allow spouse, some of them do not.
Okay. Yes, sir.
It's a legal document. So if you can just say they're living with me, they're caring for me, give them money. That doesn't quite work. We have to actually put some regulations around it. So whether or not the ad that you're actually seeing is one of those, I can't say for certain because I haven't seen that ad. But I know the caregiver agreement creates that structure around what that care is going to be, how often it's going to be, very specific, and also have the monetary.
That's on our form, Medicare versus Medicaid. So we'll get to that. Okay, so the question just for the online audience. So it's about caregiver agreement. Daughter lives with mom. She's caring for her. If they have a caregiver agreement, she can get paid, or can she get paid legally for being her caregiver?
Once again, that depends on the type of Medicaid that you're getting. There are over 60 different categories of Medicaid. The aged and disabled does allow for the caregiver agreement to pay for family members to care for them. So maybe.
Yeah. Without seeing the ad, I mean, that makes sense, right? Okay. Any online questions, by the way? Turn off your mic or *6 on your phone, or just start talking. We'll hear you. Okay. All right. So how about a spendthrift provision? Spendthrift, easy for me to say. Spendthrift provision. Spendthrift provision. It should be in the middle of your page to the left.
All right. A spendthrift provision. This is a provision that we use a lot in almost every single one of the trusts that we put together. Basically, when you're putting together a trust, you're trying to protect assets. So spendthrift provision, woo, yeah, right? Basically says if the beneficiary of this trust, the person that we're saving these assets for, if they go out and they lose a lot at the casino, that casino or those debts cannot take money from this trust. So even if the person who is receiving the benefit of the trust is a spendthrift, these assets in the trust they are protected and they cannot be used to pay their debts. So that is an extra layer of protection for that person.
So would it be beneficial to put something like this in place if I had a parent who was maybe in their 80s or 90s and they just love to gamble and we want to protect their assets?
That's why we would use a trust and specifically have that spendthrift provision.
Say that 5 times fast.
No.
All righty. Any questions about that? Online or in person? All right. How about grantor? Top left of your page, grantor.
Grantor. This is terminology time, y'all. I created a trust.
Go forward. There you go. No, like just get your.
That means I am the grantor. The person who creates the trust, they're the grantor.
Well, that was easy.
Yeah.
Right? Okay. Kind of like, yeah, just because it gets on your forehead and I just want you to look good online. Yeah, there you go.
I need an X on the floor.
I know we do, right? Transfer on death deed. That's top right on your pages. Transfer on death deed.
Okay. Transfer on death deed. So there are a lot of different legal tools to make sure that your assets go to the people, the beneficiaries that you want them to go to. We have wills, we have trusts, we have designating the beneficiary or financials. This is another tool. So for your house, the deed to your house, you can actually create a transfer on death deed so that when you pass away, that deed is transferred to the person that you nominate on that form. So it's just another legal tool.
And it really helps in the real estate world.
Makes it very clear.
Yeah. How about pour over will? Bottom right-hand corner.
Pour over will. All right. So we use this type of will when we have a trust. So basically in your will, you're going to say this person gets this person gets that person gets that. And anything else that I may have forgotten to write down in here, put it in my trust. Pour over those assets into my trust.
Okay, that makes sense, right? Any questions? I'll just check periodically for questions, but you can really ask questions anytime. Yes, ma'am. Cheryl, I remembered your name.
Correct. It's a catch-all.
So
So
the question was for the audience online, pour over will, does this include anything that I forgot, right? Or everything that I wrote down, and then
if you
whatever's
forgot
left.
anything, make sure it's accounted for. So we don't want people to say, well, what were we supposed to do with this? It's not on the list. So
What if I didn't update my will or trust and I like 5 years later down the road, and there's stuff that I've accumulated, what happens to it then?
when you're talking about things that you accumulated, are these tangible or intangible
Let's
assets?
say a vacation home in Florida.
Well, if you had a pour over will clause in your will and you forgot to put that house on there, it's going to go into your trust. If you don't have that provision in, we're going to have to go with the law
Okay.
on what happens to the house. And that's going to depend on
you
the
need that
law where the
provision
house
in.
is. And
Yeah. Okay.
it's just a helpful provision just in case you forget anything.
All right. How about bingo? Does everybody have bingo? How do you have bingo? Oh, are you going on the whole page? Oh, got it. Like if you have bingo, then everybody in the room has bingo. How about a Miller Trust? That should be bottom left of your page. Miller Trust.
Miller Trust. Okay. We haven't talked about the other trust, but basically irrevocable and irrevocable trusts are for assets. A Miller Trust is a specific tool that we are allowed to use in the state of Indiana for income. So briefly, if you're applying for Medicaid and your income is just slightly over the level that it has to be to qualify for Medicaid, we can put together a Miller Trust, we can dump your income in it, and we can get you eligible for Medicaid. Now, it's not that easy, guys, but I'm trying to make it as simple as I can. That it is a tool when you have excess income above the threshold for Medicaid.
So you can't be making like $500,000 a year and then throw all the extra that into a Miller
that doesn't
Trust.
work.
Okay.
No,
Okay.
it's a legal tool to help for Medicaid.
Okay. Any questions?
And it's for income, not assets.
Oh, that's a good point of reference. Okay. How about let's talk about asset protection. That's top left up on your page, asset protection.
All right. So asset protection planning kind of goes to get hand in hand when we're looking at public benefits, i.e. Medicaid or VA pension planning. So this is, everyone has the misconception that you have to be absolutely destitute to be able to qualify for Medicaid. That is not true.
Oh, wait, hold on. We have a question about hearing. What is it? The word asset protection. So I shortened some of these so I can make the font as big as possible. Asset protection planning was actually what Samantha is talking about.
Thank you. So we are able to protect a certain amount of assets within the law and still be able to qualify for public benefits. So when we have families who are looking at planning for the future, this would be the type of estate plan that we would do, is specifically look at their assets, see how we can protect them and still get public benefits for the individual, whether that's for them or a family member who might be special needs.
Sometimes we have a lot of questions over this. Do we have questions? Asset protection? Yes, ma'am. And so, okay. So if all of your assets are in, say, a Roth IRA, would you pull that out and put it into a Miller trust to
Not a
protect
Miller
it?
trust.
Or would you put it into a trust to protect the assets to give to your children in the future?
That's a great question. And it really would depend on the rest of your situation. If you are looking to qualify for public benefits, you would have to do something with that IRA. That would be a countable asset. But whether or not you are looking for public benefits, or if there's something else that we're looking to do with those assets, there's nothing wrong with keeping those in an IRA. And that would be a great question for a real lawyer.
A real lawyer. Well, we didn't have it on on the bingo pages, but can you just touch a little bit on look back periods?
Okay.
Sorry, I didn't prep you for that.
So there is what the dreaded look back period for Medicaid is 5 years. And basically what they're going to see is if you just gave all your money away so that you could qualify for Medicaid. They don't want that happening. They have very specific rules on what you're allowed to do and what you're not allowed to do. And they will actually look at everything that you've done in the last 5 years and make a determination whether they think that you're trying to gyp the system.
What about VA look back period?
That is 3 years for the pension.
And they changed that, I think, recently, right?
Maybe.
Yeah.
Yeah.
They added it. Yeah. There you go. They added it.
Within the last few years.
Yeah.
Yes.
Yeah. Okay. Questions? So don't just give all your assets to your kids and think that you're going to qualify for Medicaid in 2 years.
Now, there are ways to give it to your kid, but you can't just willy-nilly do it. There are very specific rules and regulations and laws that allows you to protect those assets for your family, but we have to follow them to be able to qualify for public benefits.
Oh, Phil, I think I'm seeing how you got bingo because I have I have the same word on some of these bingo cards. I just noticed that. Okay, what about living trust? That's top right-hand corner. Living trust.
Living trust. It's not a living will. Okay, so living trust, another name for that is a revocable trust. So those two are synonymous. Basically, this is a trust that you would create that you can use throughout your lifetime. And because it's revocable, you can change it anytime you want. So living trust is also known as a revocable trust.
And I don't know if this is on here. I can't remember. Irrevocable. Is it on there? Oh, there you go. Okay. So while we're on the topic, let's do that one. Irrevocable trust. So a living trust and a revocable trust are interchangeable names. Okay.
All right.
So now let's talk about irrevocable trust.
Here we go. Revocable trust. I created the trust. I'm going to put some assets into that trust and I'm in charge of it. I get to say what happens to all of that. An irrevocable trust. I create it. I put stuff in. And I give it to someone else to decide how that assets are taken care of. So that is a little bit of a difference there. And I no longer can tell that person what to do with those. So I have, in essence, given that to somebody else.
And why would somebody do that?
There are numerous laws that allow you to, this would be one of the ones that we would use for Medicaid planning, because once I put those assets into a trust and I give them to the trustee, they are no longer mine. So they cannot be counted for Medicaid or other public benefits. So that is one of those securities to be able to protect those assets for your family and not have them in your name. Okay. And
yes, ma'am. Is that part of the 5-year look back is what she's asking. So if I,
They would
created-
have questions.
oh, they would have questions. Okay. It might
there,
look
there may or
suspicious.
may not be a penalty. But that does not mean that you 100% cannot get Medicaid just because you created an irrevocable trust. They just will have to do some explaining for them.
Okay.
Also, an irrevocable trust cannot be changed. So once it is put in place, it's done.
Okay. There you go. You can have your trust back. Okay. How about, I'm going to say this wrong because I don't even know what it is, but it was on your card. So I'm interested to hear what it is. Codicil. Did I say that right?
You did. Codicil.
That's on the top left. And I think it's somewhere else too. Bottom right.
Okay. So this is a wonderful term that back in the days of typewriters. Yes, I know what typewriters are. I took typewriting in school. I am
Hey, I
that
did
old.
Oh,
Yeah. Yeah.
Okay.
So back when we had to type everything manually, if you wanted to make a change to your will, it would take a lot to retype the whole thing. So if you're making an amendment, a change to your will, that's called a codicil. Just a term for making a change to your will. Nowadays, with computers and everything, we just go in, we delete, we recreate it, we print the whole thing off again. So you rarely see those codicils happening anymore, but I've seen plenty of older wills. And so we still have some codicils hanging around. So just knowing what that is.
So does it act as like an amendment to your will?
Basically,
Okay.
an amendment or a change to your will.
Got it. Questions? All right. Sorry, we got offline for a second. All right. So let's talk about you already asked about. Okay. How about, I don't know if I'm going to say this right. Per stirpes.
I add this one because I love this term.
It's on your bottom left of your bingo cards there.
You'd think we spelled it wrong. It's supposed to be stripes, but it's not. Per stirpes. It's a Latin phrase. Basically translates loosely to by the branch. So if you think about a family tree and you're writing your will, and you say, okay, I'm going to get 50% to my son, 50% to my daughter. But if my daughter dies, I want it split evenly between her children. And if one of the children dies, I want it split evenly between their children and down and down and down the line. Wills or trust. Per stirpes, instead of writing all that out, we just say per stirpes and we're good. And we don't have to say, and then. So it tells them to distribute by the branch, by the family branch.
Okay. Sorry, the screen. There we go. Yay. We're back. We're back online. We can see everything now, Mohammed. Okay. How about, did we talk about an updated, I put that in parentheses, updated estate plan? That's in the middle on the left-hand side of your bingo page, updated estate plan.
So this is just a reminder that we do recommend that you look at your estate plan every 5 years. That doesn't mean you have to come to an attorney every 5 years, but take out your documents, look them over, look at the team that you've named. Is your power of attorney still a good person that you want them in that position? Do you have those successor agents? Have you done your healthcare declaration? Is your will still divided the way that you want it? Maybe something has changed in the last 5 years that you're like, I really do need to look at this and get updated. So that's why we do recommend you look at it every 5 years. Also, laws change. There was a change in the power of attorney law within the last 10 years. There's also the change within the living wills. So the healthcare declarations and the healthcare representatives, that's happened in the last 3 years. So laws changed. We recommend that you do look at your plan every 5 years and see if it needs to be updated.
Okay. Yeah. Things change.
Yeah. Also, if your power of attorney is like 20 years old, if that person actually tries to take it to a bank, they may have issues. That bank's going to say, I don't know if this is the most recent document. So think about keeping those updated for yourself and for those on your team who are going to take over for you when needed.
Oh, that is updated estate plan. It's just a reminder. It's on your card as a
There we go.
reminder too. Yeah, just look at your estate plan. Not necessarily go to an attorney, but I would say go to an attorney because of the point that you made. Laws change, and it's an attorney's job, an estate planning and elder law attorney's job to stay up on those types of laws, just like, and they're in it every day. And so they're seeing different cases every single day. It's just like a real estate agent. You know, you could sell your house for sale by owner. But why wouldn't you hire an agent who does that full time every single day, who's always in the market? And we can, you know, tell you what the comparables are or what the new, you know, title laws are or whatever. So, okay. Not title laws because we're not attorneys, but maybe regulations or typical things that happen in a purchase agreement. There we go. Would Jeff be happy with that?
Yeah.
Okay. All right. So let's go to long-term care. That's in the middle on the left-hand side. Did you put that or was that one of mine? Long-term care?
I think that's cut off from long-term care planning.
Probably so. Yes. There you go.
So this is long-term care, shortened from long-term care planning, goes hand in hand with your asset protection planning. When you may have been recently diagnosed with a disease that you know is going to eventually cause you to need long-term care, it's not curable. I mean, Alzheimer's. If you're recently diagnosed with something like that, you know eventually you're going to get to a point where you're going to need long-term care. Start planning. Start trying to protect some of those assets for your care. Start talking to your loved ones about what you want to happen when that time comes. Do it while you are still cognitive in the instance of Alzheimer's, to make those decisions and let them be known. This is also when we see people in crisis coming to our office. Maybe those plans weren't put in place. And next thing we know, like, well, they're locked up now in memory ward and we don't know what they wanted. And we don't have a power of attorney in place. So we don't have any legal means to take care of them or any of those things. That's a horrible, horrible decision. And I hate when those phone calls come. That's why I always say, think of the future, think of your family who are going to be helping you in that future, and do some protection and some planning for your long-term care.
Yeah, we talk about that all the time. For 7 years, every month, we talk about, when should I start? You should start now. You should have started yesterday, because if you plan ahead, you have more options, and options are good, right?
Options are good. More options the further out that you start planning.
Okay.
But it's never too late. If you haven't done it yet, you can still do it today.
Oh, I was reminded when you said Alzheimer's. I saw this post online. I don't remember what online outlet it was, but it was a sticky note that a husband had written to his wife, who had the husband had Alzheimer's, and he knew that he was declining. His memory was declining, and he wrote this note, and it said on a sticky note, "I don't remember much, but I do remember how wonderful you are." I thought that was so sweet. Yeah. Yeah. Anyway. Okay. Let's go to, okay. If you're the only person in your family, who can we appoint to be part of our team? That's a great question, actually. And it might be one of the words on here is guardian on here. Does anybody see guardianship? Yeah.
Yep.
Guardianship.
All right. So the answer is yes. There are professional organizations and people who will act as a professional power of attorney, guardian, healthcare representative, personal representative, who will take, if you don't have family or don't feel comfortable giving that authority to what family you have or friends, there are professional services out there. We have a list of referral sources that we use a lot.
Sure. Yeah.
I would say our most often reference is for a place called Scout Advocacy.
That's what I was thinking too.
Yep.
So Scout.
And that's who we give most of our referrals to. Another instance could be if it's just you and your son has special needs. Well, yes, he's family, but he's not going to step in to be your power of attorney one day. And also when something happens to you, who's going to care for that special needs son? So that's when we would get a professional service like Scout to step in and take over that guardianship or take over as trustee for the special needs trust, or to just kind of keep an eye on your special needs family member when you're gone.
So it doesn't necessarily have to be that you're the only family member. It could just be that you don't trust your family members, which, hey, it happens, right? We all have a little bit of dysfunction.
Or they're not willing to step in.
Or they're not willing to
They could
step
say, I
in.
don't want that responsibility.
Or they're not capable of stepping in. Yeah. So yeah, and Scout is a locally owned company. They're attorneys as well and who created Scout.
Yep.
Right. Okay. Okay. Any other questions online or in person? And for the online audience, I'm trying to repeat the questions, and Sarah's watching the chat box there. Oh, I meant to say at the beginning too, if you are a sponsor and you're here in the room, feel free to hop on the Zoom and pop your information into the chat box, and or Facebook or YouTube, and pop your information into there. I always try to remember to do that, but I don't do a great job of it. Miranda does a great job of putting her information in, and Dave does too, actually. Yeah, it's taken like 7 years to get them. Yeah, get them trained, but they're good now. Yeah. Okay. So what about advanced healthcare directive? That's at the top left of your bingo card, advanced healthcare directive.
All right. So this is a document that could be part of your estate planning. So the advanced healthcare directive, in the state of Indiana, you are allowed to make decisions for the future when you can't make healthcare decisions. Let me try that again. In the healthcare declaration, you can make decisions on what happens when, do I want dialysis? Do I want a feeding tube? And you can make those decisions for a point in time when you cannot verbalize those decisions.
I could say that now. Like, I'm reviewing my estate plan, which I do have an appointment with Jeff. And I say, I do not want to be, I don't want to have, I want to, if I can't breathe on my own, I don't want to be plugged into anything.
Yep. And these are all for terminal situations. Well, I must put that out there. These are terminal situations where the doctor has deemed that you are terminal, that you are not coming out of whatever situation. Yes.
Okay.
It does go along with
So
post form.
let's talk about then the post form. POST is an acronym. It's at the bottom left, and Samantha and Sarah are going to explain this because Sarah has some.
I'm just going to let Sarah do it. I think she's
sorry,
a little bit of a lag here
to do that, and now she's on the live feed. It's okay. I should have warned you. See, that's why we need Dave here. I trained him. No, I didn't train him. He picked it up eventually. But yeah, that happens. I think you can mute it. No, it's totally fine. I heard that and I was like, hey, I just have voice.
Sarah, would you like to take over talking about the post form? You had some really good notes on it.
No, I can do. So a post form is actually different than your living will. A lot of times when you go into a senior community, when you move into a senior community, or you're receiving home health services, they're going to ask you for a post form. And basically what it is a separate form that's signed by your physician. And it says whether if you are not breathing and you don't have a pulse, if you want CPR, or if you want, do not resuscitate. And then from there, it'll also ask about any medical interventions that you may want if you did opt to have CPR done. It's kind of like, if first this, do you want CPR or is it a do not resuscitate? And if you choose CPR, then we're going to go to what medical interventions do you want? And then if you want, do you want life sustaining medical interventions that would keep you alive, kind of thing. So you can have a living will that's going to take you through different things because you're alive, but the post form is specific to you're not breathing and you don't have a pulse. And your doctor has said, I agree with this, typically because there is some sort of terminal diagnosis, cancer or something along those lines. So like hospice services are going to want to post form, that kind of thing. So that makes sense.
Isn't that covered? Isn't a post form covered in your healthcare directive? Okay, they kind of go hand in hand, but most people are going to want that because it's a physician's order. The POST is physician's order. What's the rest? I wrote it down.
For scope of treatment.
Physician's order for scope of treatment. So it's like a doctor's note.
Advanced directives are like something you've said, you may have that on file with the hospital. Okay, your advanced directives. But the post form, it's like portable. You can take it. If at home and you're found unresponsive, if you're in the hospital and you become unresponsive, if you're living in a senior community and you're unresponsive, it covers you no matter where you are. Okay. So the question was, does it need to be notarized? Is that, or like signing requirements? It's you. I can pull the form up to check, but I think it's just you or your power of attorney and your doctor.
And on the healthcare declaration, it is witnesses or a notary.
Let me double check the form, what it looks like.
Hey, let's talk about Medicare versus Medicaid, which is at the top right. I mean, a lot of people interchange these or get them mixed up. And that's why I put it on the form. And you had it on your card too, I think. POA and the doctor for the post form for signing. Medicare versus Medicaid.
All right. Medicare. Medicare is for everyone. If you're over age.
Oh,
If-
we had a couple 65 or 62. Which one is it?
65. 65.
Okay.
Medicare is for everyone if you are over the age of 65. And it's kind of like health insurance. So kind of, sort of, but it does not cover long-term care. Medicaid is that system that will cover long-term care, but it is a needs-based program. Medicaid is actually open for any age. Once again, there's 60 some different categories. So there's one for any age and any situation, but it is needs-based. So that's where that is.
Okay. Any questions? Medicaid versus Medicare? And we know, and this is not a Medicare topic this month, but there are different plans for Medicare. And if you guys are interested in knowing more about those, we can connect you with somebody. Same with Medicaid planning. Actually, I think Jeff and Miranda both do Medicaid planning, right?
Yes, we do.
Okay. Non-probate asset. That's in the middle of the page on your right-hand side. Non-probate asset.
All right. So when we use the term probate, we are talking about things that happen after you have died. So this is where we go to probate court and then we decide how your assets are divided. So you only have to go to court if you have probate assets in excess of, I believe it's 100,000 now in the state of Indiana. So a probate asset would be one that is in your sole name with no beneficiary designation. So on the flip side, a non-probate asset would be an asset that has a beneficiary designation or is in joint names.
Okay. Yes, sir. Monetary value.
I believe it is 100,000 currently. So if you have less than 100,000 in probate assets, you legally do not have to go to court.
Okay. And that changes apparently,
It does change.
which makes sense, right? Question. Yes, ma'am. If I have over 100,000 in assets and I have a beneficiary, do I still have to go to court
So if you have beneficiary designations, those assets are deemed non-probate assets.
Okay, so what she just asked is an example of a non-probate asset, which was our word,
Yep.
right?
And it's
Okay.
only over $100,000 of probate assets. So those are ones that are in your sole name and do not have a beneficiary designation.
They're
Everything's cool.
I like
You're
that.
right. If they have a designation,
She said,
beneficiary
so if I
designation,
do have a beneficiary, everything's cool.
everything's cool.
Everything's cool. Yeah. All right. Let's go to, we talked a little bit about caring for someone with disability. What about a special needs trust?
All right. So a special needs trust is a very specific type of trust with very specific language, very specific. Like when we show it to people, like, well, can't we change? No, we cannot change that language there. It has to be just so, but it's put in place so that an individual who is receiving or will be receiving public benefits can receive a large monetary amount, like an inheritance or a windfall through a lawsuit. So, for example, you have a special needs child. They are your only child, so they are going to be inheriting everything from you. But they're also on a public benefit like Medicaid, and they will be on Medicaid for the rest of their life. You don't want them to get kicked off of Medicaid because they received their inheritance. So by setting up a special needs trust, we can funnel those funds into the special needs trust. They can receive their inheritance and they can still keep their public benefits. And that's a very simplified version. It's more complicated than that. That's where we're going to go.
Yeah. Yeah. I mean, that's kind of the level we're staying at anyway.
Yeah.
Just because, again, everybody's situation is different. Yeah.
It is a legal tool that we can use. Question.
It doesn't matter the amount.
Does
This
not.
is the of the inheritance, you mean?
It does not matter. Now, in excess of certain amounts, there's additional language that has to be put in and there's additional things that have to happen, but we can still protect that inheritance and that allow them to keep their public benefit.
That's the whole other topic, Medicaid. There are lots of things about Medicaid that I personally don't agree with, but that's a whole other topic.
Your question basically was, that seems kind of wrong.
Or it's surprising to you that somebody would inherit a bunch of money. They're receiving public assistance and they can still have this money.
Correct.
Right.
That would not happen if the trust didn't exist. But one of the things about special needs trust is the beneficiary is not in charge of the trust. So in other words, it's like an irrevocable trust where those assets do not belong to them. They can be used for them, but they do not belong to them.
So
we'll call it a separate category.
Yeah.
I think that's a good way to think of it. A lawyer might have a different opinion, but in my mind, it's kind of its own thing.
Yeah. Because I mean, maybe it was created to if somebody who is, I'm just going to say, maybe they're autistic and they're your only child and you have whatever, $1 million in assets. And that might be a higher, I don't know what the limits are, and you don't want to just give your autistic, whatever, 37-year-old child $1 million. I mean, they could be open for it to be taken advantage of through scams. They could, who knows what they're going to do with that. You don't want to give that to them because they're not capable of being fiscally responsible, right? I mean,
that's one way to think about it. Yeah. Another example that we use a lot of times, we work with litigation attorneys. So imagine maybe your daughter was in a car accident with your grandchild who's 3. That was a horrible car accident. It snapped the spine of your grandchild. That grandchild will now need care for the rest of their life. They're going to receive a settlement in court. Maybe it is $1 million. The care for that child over their lifetime is going to well exceed what they received in that settlement. They are going to need public benefits. So by having a special needs trust, they can have the public benefits for their health care. and they can use that money for other things that Medicaid won't cover for their lifetime. So that's one of those really horrible situations that this sort of trust is meant for.
Yeah, that's great. Good stuff. Okay. Creditor claim period. This is on the bottom left of your bingo cards there. I'm sure many of you have bingo by now too. Creditor claim period. What's a creditor claim period?
So this is a terminology that we use for decedent's estates. So when someone has passed,
Wait, what's a decedent?
someone who has passed,
I was just playing devil's advocate.
that's okay. When someone has passed, there is a time frame that the law allows for creditors to make claims against the estate. That is the creditor claim period. For most creditors, it is a 9-month period. For some creditors like the state or the United States of America, they get longer. It also depends on whether or not you open up an estate, if it's supervised or unsupervised. That can also change the timeline. But a good rule is that creditors do have 9 months to make claims against the estate. So when someone receives their inheritance, they got to wait 9 months to spend it because there may be a claim against the estate.
Oh, that's okay. That makes sense because they could, let's say somebody passes, they give their inheritance to their kid. It's $100,000 and they're like, woohoo, I'm going to go on a shopping spree. And you would advise them not to do that because there are 5 credit cards totaling whatever, $50,000 out there still
We
open.
would advise against that.
Okay.
But once again, it depends. There's a
I'm
lot
just
of
throwing numbers
variables
out, by the way. Yeah.
There are different variables. Once again, I said it depends on if those assets were in a trust, the creditors cannot make a claim against a trust.
So there's
So
all
that's
these,
protection.
for lack of a better term, loopholes. I mean, and I'm not saying that like, oh, we can get out of this, but it's just special circumstances that may be unique to the actual person, to each individual. And that's why it's important to, again, hire professionals for this type of stuff, right?
Yes. And there's a very specific way that the creditors have to make their claim. So, and if
And
they
the
don't
layperson-
follow those rules, you don't have to pay them.
The layperson wouldn't know that, right? So
They
let's
would
say
not.
I'm the child that inherited $100,000 and whatever, Discover calls me and says, hey, your mom gave you $100,000 and we have she has an open line of credit for $50,000. So give us that money. That's probably not the right way to do it.
They can't call you and ask for that money.
Oh,
That's not one of the ways they can do it. They have to file with the court.
okay.
Once again, the creditors have a very specific process they have to follow to get paid in a estate.
Any questions? Check online here. Is that you in the chat box? Oh, that might be one of our sponsors that popped their information in there. Okay, how about what's a named executor on your bingo form? That's in the middle to the left. Named executor.
So that was probably part of a longer phrase. An executor would be pertaining to your will. So we also call them personal representatives. So basically, have you put together a will? Have you said who's going to take care of that when you're gone? That's naming an executor
Like an executor of your
estate.
Okay. Yeah. How about self-dealing? That's at the top right-hand corner of your bingo form. Self-dealing.
All right. Let's try to put this into plain English. Self-dealing. So there are laws that state that a trustee is not supposed to take advantage of the assets in a trust. They are not supposed to gain benefit from managing that trust. Now, sometimes the trustee is a beneficiary, So that's kind of counterintuitive. As a beneficiary, they're supposed to benefit from the trust, but they're also the trustee. So this is kind of that self-dealing. It's a special clause that we would use in a trust because the trustee is a beneficiary, is supposed to be receiving benefit from this trust. So kind of says, I know the law says one thing, but because of this special circumstance, we're allowed to do this.
Okay.
Once again, don't like to say loopholes.
I know. Yeah.
But the law is vast. The law is vast. And there's so many if and or buts in
and
it
special circumstances.
and
Yeah.
special circumstances.
Yeah. Okay. Any questions about that? Self-dealing. Okay. How about a power of attorney? It's at the top left.
It's at the bottom.
Oh, and is it at the bottom? Yeah, it's at the bottom left as well. Thank you. Oh, and it's at the bottom right. You know why I left it? Because whenever anybody mentions the power of attorney, I feel like it's my duty to say, what happens to a power of attorney when you die?
They no longer have any legal standing.
The power of
Yes.
attorney dies too.
That's
When
a good
you
way to
die,
say it.
Power of attorney dies. Not
Correct.
physically, but the form power of attorney dies. Yes, sir. Can they be your executor, the power of attorney? Can the power of attorney also be the executor of your
You
estate?
can name that person for both positions. So you can choose anyone. They can be the same person. They can be different. So it's up to you who you choose on your team.
Does anybody need more bingo things? I'm running out. You need more?
All right. I'm sure that most everyone in the room, or probably everyone in this room, already has their power of attorney in place. They know what a good thing it is, that if a time comes that they need someone to take over their financial responsibilities to make decisions on their behalf, they have that person named in a real legal document that person can take to the bank and take over their responsibilities for them. That would be your power of attorney, who would have the power, given the authority, to handle matters on your behalf at the time that you decide. So even though you have this, that doesn't mean that person can just willy-nilly take it wherever they want. You still have control to decide when that person can use their power of attorney on your behalf. Or a doctor can make that decision for you if you are incapacitated.
Oh, yes. Thank you. So I was just getting ready to say there are lots of different types of power of attorneys, right? There's a real estate power of attorney, there's a medical power of attorney, and I'm sure there's lots of others. Financial. Yeah.
There are different powers of attorneys. The one I was specifying was your general durable power of attorney or your financial power of attorney. The healthcare power of attorney, a few years ago, that terminology has changed to your healthcare representative. It's grandfathered in. You're still good to go. But on your 5-year looking at your state documents, you might want to get that one updated. So your healthcare power of
That's
attorney
good.
makes healthcare decisions for you. And in Indiana, that name has changed to your healthcare representative, who is given the authority to make decisions on your behalf.
Okay. I just came up with a question because you said in Indiana. So let's say I live in Indiana, but my kids live in, I think my son wants to go to the West Coast sometime, California, let's say. So my kids live in California and I live in Indiana and I want to update my estate plan. Do I need to go to California or do I update it here or vice versa? What if I lived in California, but my kid, where?
Those documents follow you.
Okay.
So you are living in the state of Indiana. They follow the Indiana laws, and you can name someone in a different state, but all your documents are based on the state that your documents are based on the state you are living. When you move to another state, it is highly recommended that you have an attorney in that state look over your documents to see if there are any different laws in that new state that might affect your estate planning. That doesn't mean that they're null and void, but there might be little tweaks that could be used when you move to a new state.
What if I go to Florida for 6 months out of the year?
That has to be a residency question.
Yeah. Which state am I a resident at? Yeah.
As
Yeah.
you said, probably the 6 months and 1 day, it would be what is considered your primary residence.
Yeah. Another question about that. Oh, and Jeff's office you guys are probably part of a larger network. You could probably refer us to somebody in Florida or California, wherever we move.
Yes. So Jeff has connections throughout the United States with other certified elder law attorneys that he could recommend based on where you're looking to. And
Okay.
yes, we have used those multiple times.
Yeah. It's the same with real estate agents who help seniors downsize. We're part of a larger network. Somebody asked this question earlier. That's why I'm bringing it up. And yeah, we can link up with people in other states, and people in other states link up with us all the time. We're working with a couple of people right now that were referrals from other states, Florida and Arizona, actually. So, okay. We talked about this a little bit, but let's just cover it because we have time. Will. That's at the top right or top left. It might be somewhere else too. What can you tell us about wills, Samantha?
All right. I'll answer, talk about wills, and then I see your
Oh, it's
question.
Okay.
Yeah. Wills. I mean, what are you going to say? The will is a legal document where you, number one, designate your executor, or your personal representative, where you are going to designate who is going to take care of your estate when you pass. Also in the will, you are going to say, what happens to all my stuff when I pass? The will can designate, I think I'm going to go down a rabbit hole. The will can designate non-tangible assets, such as money in the bank, your not your IRAs because they're beneficiaries, non-tangibles, things that you can't put your hands on, though you can touch money, but they're considered non-tangibles. Whereas if you want to designate what happens to your ring or your baseball collection or your bats, that could be a appendix to your will. That's not part of the actual document. So when your executor follows the law, they are going to distribute the non-tangible assets of your will as the will states.
So a will is part of your estate plan. It's a piece of your estate plan.
It is. Yeah. See, I knew I was getting like too deep into that. It's a piece of your estate plan that basically says, here, I will eventually die. We all do. Here's what's going to happen next. Here's who's going to be in charge of everything. Here's how I want it to happen.
So if I just have a will and nothing more, I don't really have a fully completed estate plan, right?
We would recommend that you have other pieces like the power of attorney, the healthcare declaration, that you have more pieces than just a will. We would highly recommend that.
Okay. Yes,
Sorry,
ma'am.
question in the
Yeah.
back. I am not familiar with that term. That is probably something that Jeff could talk about, or he is an attorney, but not a tax attorney. We're state attorneys. He may refer that to a tax advisor to give you better advice on that. In your trust, you could name whatever beneficiary you want to. So if you want to do a generation skipping trust where you skip over your children and give it to your grandchildren or even your great grandchildren, you're allowed to do that in a trust.
Or
My grandfather set up a great grandchild trust.
Oh,
So my children are benefiting from that trust, and I am not getting any of it, but it's for my kids. Estate taxes are not that big of a deal. Like, you have to be a multi-millionaire to worry about estate taxes these days.
okay.
Definite law changes there.
Okay. So let's go to grantor. That's in the middle left-hand side of your
Did we
bingo
do
page.
grantor?
Grantor. Did we do grantor?
We do grantor.
Okay. Sorry.
Yeah.
Skip.
Remember, the
We did-
grantor is the person who creates a trust.
Okay. Yes, we did. I do remember that. We did self-dealing as well, didn't we? And we did caregiver agreement. We talked about trust. Is there anything more you want to talk about on the trust?
Oof.
Any questions?
Yeah. Are there any more questions about trust? Trusts aren't just for the extremely wealthy anymore. I mean, they are just a great tool to use. As I said, pour over will into the trust so nothing gets forgotten. It's a way to protect assets for the future and still get public benefits. they're a way to avoid probate, because if you put your assets in the trust, they aren't probate assets. They are non-probate assets. You don't have to go to probate court.
But
So
I don't
they're-
need to be like a multimillionaire to have a trust. I could have a house and that's my only asset.
Put the house in the trust, you're protected.
Okay. What about community spouse? That's in the middle right-hand side. Community spouse.
So this is a term. This is a Medicaid term. So if we have a couple, we have one who is the Medicaid applicant and their spouse is called the community spouse. I don't know why they came up with that term. They couldn't just say it's a spouse. Nope. They have to call them the community spouse.
Yeah, that's odd. When I saw that, I thought, is this talking about like, what is it called? Or well, Sarah said multiple wives, or like, when people don't formally get married, but they live together. What is that called? They live together. Common law. Yeah.
No,
Doesn't have anything to do with that.
This
Okay.
is their legally wedded spouse. They
Okay.
just call it the community spouse. I guess the reason that we wanted to touch on this is the way that Medicaid is set up. Just because in a married couple, one of the partners who needs Medicaid can get Medicaid without making the other side, the community spouse, completely destitute. So that is kind of,
Okay.
I'll make it really simple. Like you take everything and give it to the other person, boom, they're good. But it's not that simple. Don't get me wrong. It's not that simple, but just because you're married and one of you needs care and the other doesn't, they don't want to impoverish the spouse who doesn't need
Got it.
care. So
Okay.
there are plenty of legal tools that we can use to get Medicaid for
One
One?
spouse without the, that's actually really good, right? So I'm married.
and there is a better, like, think if this happened to you on this sheet right here, it kind of talks about that community spouse and how one can get Medicaid and they can still
And
keep
if
their
you're
assets.
online, we'll pop those into the Google Drive. Yes, ma'am. Does this protect your house? Yeah. So let's say my spouse needs to go into memory care, but I'm independent. I want to live in my house, and spouse needs to pay for that memory care, which is super expensive, by the way. So we're going to put them on Medicaid, but I want to keep my house.
You can keep your house. We're going to have to do some planning. We're going to have to use what legal tools we have to make everything kosher. But it is absolutely, you can stay at home and you can keep your house. You do not have to give up your house.
Okay. And this is again where planning comes into place. Planning
Remember that
early.
look back period,
Yeah.
transfer penalties.
Yeah.
There are things that can be done legally, but we have to be very cognizant of the rules and regulations and laws behind that.
So not only if we fail to plan, we limit our options, but also it could cost us more money. So now we have limited options and we have to pay more for those limited options, right?
Mhm.
So again, like drilling at home, plan early and look at it often, right?
Yep.
Testamentary trust.
Testamentary trust. This is the big long word that basically says this is a trust that will only come into being when you die. So this is a trust that is written into your will that comes into being when you die. So it's not a trust that you created while you were living, like your revocable trust or irrevocable trust. This only it'll happen when you die. So let's use it for instance. I have a trust in my will. This trust is for my children if they are under the age of 25. So I have a few more years before this trust will not even make any sense. But if I was to die today or tomorrow, not all my kids are 25. So their inheritance would be funneled into a trust and it would be taken. It would have a trustee to manage those funds because I do not believe that my kids could currently manage an
Frontal
inheritance.
cortex hasn't developed yet. And we're waiting and waiting and waiting. And I can't wait till that day happens
Yeah.
right now. Right.
But there's no need for me to create a trust now for their inheritance, but it will be created if and when I die and they are still under the age of 25. So that's an example of a reason to have a testamentary trust.
And I was thinking as she was talking, do I need all of these things that we're talking about? And I'm going to guess the question is, it depends.
It does. It depends
these
on
are
your
a lot of
situation
things,
and
right?
what your goals are. Some people's goals are to live at home, live the best life they have, and we can help with that. Some of them want to be able to pass on a significant inheritance to their family. Those two different goals have very different planning strategies, and we would use very different legal tools to accomplish those goals.
Yeah. And I was going to say one's not right or over the other. It's really a preference. Some people just have the idea, this is my money. I'm going to spend it while I'm living and my kids will have
Nothing
their
wrong
own
with that.
money. And other people feel like, I want to leave something to my family. And there's nothing wrong with that. It's like
somewhere in the middle.
Somewhere in the middle. Right. It just goes along with what are your goals? Yeah. There was something else I wanted to talk about. We talked about plan for a loved one with disability. Oh, what was that word I saw here? Funeral planning declaration. Maybe that was it.
All right. Funeral planning declaration. So this is just an additional legal document, part of your estate planning. The importance of this document is that when you die, in this document, you're going to designate who is in charge of your funeral so that when you're gone, the family knows, okay, this is the person who's in charge of it. You can also state your wishes for that funeral. So you can tell your family, I want to be cremated or I want to be buried. And I've already bought that plot and it's located here. Or you say, I want this type of flowers, or I don't want any flowers, or I want a band, or you can basically plan your own funeral and tell your family what your wishes are in this document. I'm sure many of us have gone through this and just the turmoil that you are in. And then you have to plan the funeral and you have to think to yourself, what did this person want to happen at this point in time? It's hard when you're grieving. So by having this funeral planning declaration already together for your family, it takes that stress off of them and it leaves them to just really do what they need to be doing, which is grieving at that point.
So one of our audience, that was probably one of the best things that their parents and in-laws could give them was the gift of a funeral plan, because it gave them space to grieve. So they didn't have to go through making a bunch of decisions when they're trying to grieve. So we're going to have next month a tax person, a funeral person, and an attorney. And we kind of shifted things around. And so we could do legal bingo, and we're going to talk more about what the funeral planning is for or could be for. But I think you could also do a mixture of both. You don't have to have every single detail of your funeral planned out, right? You could just say, I want these things at my funeral, or I want this to happen. And then you can do whatever else you want.
And then make up the rest of it as you go. Yeah. You can fill out that document as much or as little as you want.
And there are people who would say that a funeral is for the people who are still living as a process of the grieving. It's part of saying goodbye. And so, some people say, oh, I don't want a big to do. I don't want to, and that's fine too. And also, and again, we'll talk about this more next month, but it is a gift that you can give the people that you've left behind so that they can work through the grief process. Yeah.
Yep.
I think we've covered everything. Do you see anything on your bingo cards that we didn't cover or that you would like us to talk more in depth about, or Samantha to talk more in depth about? There's one testator. Did we cover that?
We didn't, but it's a wonderful term. It is the person who creates a will. So if you have a will, You are the testator of your will. You created it. If you're a male, if you're female, you're a testatrix.
Oh.
Yes.
Okay.
Oh, you had it right there. She knew. She knew. So it's the person who creates the will.
Say that 5 times fast too. Lots
No.
of lots of tongue twisters in elder law planning.
Yeah.
Elder planning law. Yeah. Okay, so I'm going to open it up real quick for general questions before we give away some door prizes, bingo prizes. Questions online? All righty. And the forms that are here in the room, if they're not on the Google Drive, we'll pop those into the Google Drive either this afternoon or tomorrow. And let's do some drawing. Says everybody in the room, do you have your name in the basket? There you go. If you are online, thank you so much for attending. On the form, on the PowerPoint, I got really fancy this month, and there's a link to your feedback form, and there's also a link to RSVP on the one of the first slides of the PowerPoint. If you can click on that, it's in your Google Drive in PDF form or PowerPoint form. And you can go to one of the first slides and click on the link for feedback and also the link for to RSVP for next month. So thank you for attending online, and we'll see you next month.